Hello and welcome to our question and answer session on health and safety considerations in the coronavirus and getting back to work. Recorded on the 26th of May 2020, hot on the heels of the announcement yesterday that all non-essential shops can open from the 15th of June. As retailers are navigating the reopening of stores in the coming days and weeks, they're no doubt going to be faced with both practical and operational challenges, which their legal and HR teams are going to be grappling with. Key questions that come to mind are things like, as lockdown eases, are shoppers going to return in force to the high street and their out-of-town shopping centres, or will individuals, having got used to sourcing their items elsewhere, continue on as before? Predicting how the demand for physical stores, some of which have been closed for some months now, will respond and play out is just part of the puzzle. But now that retailers have got a firm timetable to work towards, TLT has brought together our retail sector specialists, Duncan Reid, who is a health and safety partner in the regulatory team, and Liz Cotton, who is a retail employment specialist partner, who'll provide some insight into some of the likely questions that are going to be arising for retailers from a health and safety perspective in the next few days and weeks. So first questions for Duncan. Why is this such an important issue for stores to consider?
Thanks, Sarah. Well, the government guidance for retail stores, which was published a couple of weeks ago on the 11th of May, and then updated yesterday, sets out how retailers need to work safely by incorporating the 2 metre, now common to all of us, social distancing requirements into their premises in the workplace. The updated guidance that was published yesterday wasn't a wholesale change to the guidance that was previously provided. There were some small tweaks around use of fitting rooms and handling goods. So there's no need to revisit your procedures if you've already looked at the previous guidance. But one of the main starting points for how retailers need to look at what their change in requirements might be is how large the premises are that they're operating in, and how many people do you anticipate will be in the workforce and the workplace, which will include shoppers, of course. The guidance confirms that if the social distancing requirement can't be complied with, then businesses will need to consider whether the activity needs to continue for the business to operate. And if it does, then adequate control measures need to be put in place. So, for example, the screens and barriers that we've seen in the supermarkets already, and reducing face-to-face working and increasing the frequency of hand washing and surface cleaning.
Right, so those are some really good pointers, and some of those things we've sort of got quite used to seeing in shops already. Is there anything else that retailers need to do right now?
Yeah, absolutely. Those in charge of stores and other workplaces where individuals are going to be returning over the coming weeks will need to prepare a COVID-19 risk assessment following the government guidance to demonstrate how they're dealing with the risks presented in the workplace and what measures they're taking. This also follows the employer's common law duty of care, which Liz is going to touch on later. And it's likely that retailers are going to be seeking to reach out to their health and safety consultants who already know and work with the business, and they're going to be the key people to assist them here in relation to looking at every aspect of the operations to consider whether a COVID-19 risk arises and whether things need to be done differently. For those retailers who have chains of stores, each store will need its own risk assessment, as each store is fundamentally different in terms of its setup, capacity, makeup, whether it's in a shopping centre or on the high street, what have you. But there's also common risks across the estate, which will form standard working practices, and this information and knowledge can be shared. I think the key message on the risk assessment and seeking to implement it for retailers will be communication and review. So they really need to be focusing on those two areas to make sure that the risk assessment is as effective as possible.
All right, that's really interesting, Duncan. Thank you. So with that very helpful overview of what retailers should be bearing in mind, Liz, what is it that employers should be doing to make sure that these measures are implemented on the ground?
Thanks, Sarah. So this is where the third element of the duty of care really comes into play. So as Duncan mentioned, you get your risk assessment in place, you implement a safe system of working, and the implementation stage is perhaps one of the most important elements of this process in terms of getting to grip with your obligations, because in our experience, this is really where the risk area is and where most employers are likely to fall down. The interface between the more theoretical side of what the risk assessment says and then obviously putting it into practice, and staff and your customers obviously putting it into practice too. In terms of the key elements of good implementation, the essentials can be summarised as follows. Good communication for starters, and it's worth mentioning at this point that there is an obligation on employers to consult on matters of health and safety with representatives. So where businesses have recognised unions, the obligation will be to consult with trade union representatives. For those businesses who don't have recognised unions, then it will be with employee representatives. So communication is key. Staff need to know what they're expected to do in line with the risk assessment. Training is also very important for the same reason, really. Staff need to know what's required of them. Signage and the use of visual aid is also a really good tool employers can use to get the message across. Repeating the instruction, perhaps by an email that goes around each morning to staff, reminding them that they're not to come into work if they're showing certain symptoms of COVID-19, or perhaps through the tannoy in store, just reminding customers of the same, or the need to wash hands regularly, that kind of thing. And again, management intervention, what they should be doing where processes aren't being adopted and followed by employees and third parties. This obviously is going to be happening while people are busy at work, and really it's probably not, health and safety issues are probably not at the forefront of their mind when they're trying to serve customers and the like. So reminding staff through the use of signposting, putting markers down on the floor, setting out the 2-metre guidance they serve as good reminders to them at all times to be following the social distancing guidelines. Again, communication is key. Where you do have situations where staff aren't following it, our advice would be you don't rush to disciplinary action immediately without giving the staff the opportunity to explain. And obviously, if you know that you've trained them properly on it and there's repeat offenders, then you're on safe footing to then obviously follow your own disciplinary procedures. So.
Sure, right. Yeah, that all makes sense. But that's really useful sort of practical guidance on what to do when employees are already at work. But given that these obligations are going to bite from the moment that your employees step foot back into a store, is there anything that employers should be considering before the return to work?
Yes, yes, absolutely. As you say, the measures need to be up and running so that employees know what they're doing on day one of the return. There'll therefore need to be some lead-in and some communication with staff prior to day one. For example, you might roll out an online training module on the new system or the way of working, or set some question and answers out, which you circulate to staff in advance of their return. It's worth reminding employers that obviously a large number of organisations currently have staff on furlough through the job retention scheme, and training is permitted if they're on furlough, albeit there needs to be care taken that the pay doesn't drop below the national minimum wage during that period.
Great, thanks Liz. What about this, what will probably be quite a common scenario that somebody actually refuses to come into work because they say for themselves that they don't feel that it's safe for them to be there, and they point blank refuse to come along on the return.
Right, yes, thanks. This is an issue which employers are inevitably going to be asked as they move into the next phase of lockdown and bringing people back into stores and obviously warehouses and the like. Home working, and the guidance hasn't changed on this, home working where possible should be the preference, but obviously in a lot of retail environments, home working isn't possible for all. Again, furlough, whilst the scheme's still active, should be considered for those who are eligible. But again, if that's not a possibility for your particular workplace, then employers need to be mindful of the health and safety protections. First, it's automatically unfair to dismiss an employee for health and safety reasons. And also, there's a right not to suffer a detriment. So if you've got an individual who's saying that they don't want to come into work because they believe there's a serious and imminent danger to their health in doing so, then care I've just referred to. Really, the key will be to establish by discussion with the individual together with them to alleviate their concerns. Again, I mention here because the chances are if one employee's got a particular concern, then others are also likely to share where they don't comply with a reasonable management instruction. But as I said, care needs to be taken where the reason for the refuse, just to reiterate, where an individual feels the risk is serious and imminent and it can't reasonably be controlled, then a dismissal in those point to make as well. Aside from the health and safety obligations, there's also protections in the UK for whistleblowing. So individuals that speak up, safety protections, not to suffer a detriment and not to be dismissed under the whistleblowing legislation, and compensation scenarios. So it really is one that employers need to be thinking about and getting right. Obviously getting your policies in place, your whistleblowing policies and your health and safety to use this time between now and the 15th of June to get everything in order. Thanks, Sarah.
Great. Thanks, Liz. That's really helpful. An illustration where the employee themselves feels that if they come back into it, that there's a risk to them. Could you perhaps provide some comments on what employers should do refusing to come back to work because they live with somebody who is extremely clinically vulnerable? Can an employer insist that an employee returns to work if feel that it is a risk? It's somebody who they live with who's very vulnerable. Yeah, okay. Some of the same considerations apply, obviously. So furlough, obviously, to be considered. Again, the obligation not to be dismissed for health and safety reasons, and obviously the detriment I just referred to, the detriment. It is worth noting that the protections under the health and safety legislation have a very wide scope, and so they can include a danger, not just individuals. So it is potentially wide enough, the protection, to include family members or others that are residing in the employee's home. Associative discrimination is something that carers, for example, potentially could bring claim in that category that they are actually disabled, and therefore care needs to be taken in how you then manage the individual that's saying they can't come in because they're concerned about that individual. Sorry, I was just going to add, in terms of, again, it comes down to dialogue with the individual employee and any representatives. You'd want to be sitting down with them and finding the person at home's got, what's the local infection rate like, for example, what is the government's most recent guidance, because obviously it's changing on a daily basis in some cases, and obviously what already to help see if you can work together with the individual to alleviate some of their concerns. Great, thank you. So let's address some of the sort of have. I've read quite a bit about some employers introducing compulsory temperature testing for employees as they arrive at work to have their temperature tested on arriving at work.
Yeah, okay. Yeah, this is something that won't be put into practice by introducing this. Assuming that it's been identified in your health and safety plan as a reasonable measure to reduce risk, failure to comply with the reasonable management instruction. You'd want to be, again, having dialogue with the employee. Why are they refusing? Is it because they think they'll give a false positive result for it? What are the risks to colleague if they don't comply? But if you get no reasonable explanation, refusal suggests they might be concerned, then the refusal, as I say, could be something that needs dealing with under your disciplinary procedure. Communication is obviously the key here, and finding out.
And then another but quite specific point, how should you always deal with pregnant employees?
Yeah, again, it's something that on safety grounds are concerned, but there's extra protections for those expectant and new mothers that apply, that employers need to think about now and put in a discrimination law recognises pregnancy as its own protected characteristic. So they've got the right not to be discriminated against on the basis of their risk assessment. So this is separate to the obligation to carry out a risk assessment for the organisation. But if you've got an employee that tells you that they're pregnant, then that triggers an obligation for you to conduct a separate risk. Typically, the assessment would look at things like what role they do, whether they can work from home, alternative roles and responsibilities, whether social distancing can be complied with. What employees are within the category of clinically vulnerable when it comes to COVID-19. And they've been told to take particular care to adhere to social distancing guidelines. And for employers is that where individuals can't work from home, then obviously social distancing needs to be followed very closely for this particular category. Obviously it does for everybody, but this all the more important for those clinically vulnerable. And where they can't actually accommodate proper social distancing measures, then the individual employee who's pregnant should be suspended on full pay, not statutory sick pay. So the entitlement will be medical suspension in line with their rights as a pregnant person.
Great, thanks, Liz. I'm sure that'd be really helpful guidance for a lot of retailers. So moving back to health and safety considerations more generally, Duncan, so with all these changes that are going on, has the law relating to health and safety in the workplace changed at all?
Thanks, Sarah. The legal framework around health and safety and how it applies in the workplace hasn't changed at all. So we're still under the Health and Safety at Work Act. Retailers will need to show that they've taken all reasonably practical steps to protect those in the workplace from health and safety risks. And following the published guidelines updated yesterday for retailers will be considered to be the legal benchmark for compliance. So the message is fairly clear. If you comply with the guidelines, then you're complying with your legal obligations. The duty to ensure that health risks are reduced to a reasonably practicable level includes those who aren't employees but who could enter the workplace, so shoppers, contractors, and any other individuals who are going to be present in the workplace. And the practical measures that are going to be taken by the retailer in following the guidelines will be designed to reduce for the risks for those third parties as well. And that's why, for example, the guidance contains specific recommendations relating to fitting rooms for customers or measures that are going to be put in place when customers handle merchandise.
Great, thanks, Duncan. And just another question. Will anyone be checking what employers are doing, or retailers more generally, to keep everybody safe in the workplace?
Again, there will be no change to the requirements currently in this regard. So basically, there's no specific requirement to have your COVID-19 risk assessment or any changes to measures adopted in the workplace checked by local authorities who previously have had responsibility for ensuring that retailers, for example, on the high street are safe or the HSE, who've certainly been involved in some of the discussions over the last couple of weeks about ensuring workplace safety. But there is a requirement that retailers who employ more than 50 members of staff will be encouraged to publish their risk assessment on their website. There's been some discussion as to whether it's their actual risk assessment or whether it's a summary of the risks identified and the measures that they're taking. So I'm sure people will certainly be considering that over the coming days or weeks. The main thing really to raise at this stage is that if concerns are raised about the measures that are put in place by either employees, as Liz referred to earlier, or customers, then it's highly likely that either the exist. And then if that happens, it's important for those who are in charge of that particular make sure they're using the latest versions of those documents, because it's likely that those will be subject to sort of changes and different iterations over the period of time, and on the relevant latest up-to-date COVID-19 risk assessment, which can confirm compliance with the requirements. And then those in charge will be able to easily demonstrate to anybody who is inspecting what steps have been taken to protect against the risk of transmission of the virus. We've seen police intervening when concerns of safety have been raised by shoppers and others, linked to some of the wider powers that they have to know what to do if there is an inspection. If the measures found to be taken by a retailer are not considered to be sufficient by those inspecting, then there's a risk that either are served. So local authorities have that power, HSE also have that power. Mm-hmm. And if that happens, it's really important to get legal advice as soon as possible, exactly what information those notices should contain. There's also a specific period of time for appealing those notices if they have been secured incorrectly, is certainly likely to be a matter for debate in terms of whether the arrangement to meet the requirements or whether it's the operation of the arrangements. So how are the arrangements being put in place? And this really circles back to some of the points that Liz was making earlier around if following an enforcement notice, no corrective action is taken, then the HSE have indicated, certainly in their press appearances alongside the government and select committees, that they won't rule out criminal prosecution to punish non-compliant businesses in the circumstances. So that is again. However, the regulators have said that they're going to be taking a measured approach here in relation to any potential fines that they could impose for breaches of the additional risk of potential civil proceedings from employees and or members of the public who could have visited stores. So it's really important that employers look at arrangements for both employees and members of the public.
Right, that's really useful guidance. Thank you, Duncan. And our final question, another one for Duncan. What happens if there's an outbreak or a cluster of cases arising in a specific workplace?
Yeah, I mean, this is quite into account some of the track and tracing initiatives that may well be more advanced by the time the workplace returns to. I think the advice is if local managers, those in charge, become aware of an outbreak or a cluster of cases that are particularly arising in a workplace, you need doing the next steps very carefully, because the fact that there's an outbreak or a cluster of cases emerging or emanating from a particular workplace is a fairly clear indication that perhaps the measures that are being taken to protect against the risk are not effective, and that there is indeed an increased risk there of regulatory activity. So and looking in quite close detail what measures have been put in place. It seems to be the case that they're not effective. Cases and consider what the appropriate action should be. But I think certainly the key message here, again, coming back to openness with employees about what the health implications could be, is really key, and just reinforcing those messages so that people report any cause of concern, so that it can then be communicated back through to the rest of the workforce. I think one of the legal obligations that's been clarified quite helpfully actually by the HSE to what the reporting requirements might be in these sorts of circumstances, and the HSE have confirmed that if employees have contracted COVID-19 in the workplace and there is reasonable evidence that it's caused by an exposure at work, then that would fall within the reporting requirements under RIDDOR. So therefore, the employer need to complete the standard online form on the HSE's website. And I should add at this stage that there's an awful lot of very helpful and useful information on the HSE's website about the risks in the workplace.
Great, thank you, Duncan. Well, with that last answer, that brings us to the end of this session. So thank you very much, regulatory side, and Liz Cotton answering the employment law questions. We've been through a number of really key and are going to be arising in the next few days and weeks, and hopefully come up with some good, helpful, practical advice on how to deal with those. Just in finishing, we should probably highlight that although we've had some really good steers today, this is obviously a very fast moving situation, so it's absolutely critical that up to date with the guidance that is being published by the government on a regular basis, and obviously constantly being updated. So just to close, keep tab, and if you have any further questions or any queries that we haven't covered in today's session, then please do get in touch with our speakers, Duncan and Liz. Details on the link with this recording, or alternatively you can get in touch via the TLT website, which is tltsolicitors.com, and contact us that way. But thank you very much for listening, and thanks again to our speakers.
Sarah.
Thank you.